In particular, the fact that the probation officer has assessed you as presenting a very high risk of serious harm towards the current victim and to any future partners. An assessment with which I agree. I am not satisfied that the seriousness of these offences justifies a discretionary life sentence pursuant to Section 285 of the Sentencing Act 2020, as you have no previous convictions. I have considered whether a standard determinate sentence is appropriate. If imposing such a sentence, the least period of imprisonment that I could have imposed in all the circumstances of your case, after a trial, to reflect your overall offending, would have been one of 26 years. Allowing the full 1/3 credit for your guilty plea, the sentence would have been one of 17 years and 4 months. Such a sentence would not fully address the risk that you currently represent. And I consider it necessary to impose an extended sentence in order to protect the public in the future. The extended sentence is made up of 2 parts. A custodial period, which will be no longer than the 17 years and 4 months period I mentioned, and an extended licence period of 3 years, making an extended sentence of 20 years and 4 months duration in total. You will serve 2/3 of the custodial period in prison, before the parole board will consider whether it is safe to release you, and if so, on what terms. Once released, you will serve on licence any part of the custodial period which remains, and you will then be subject to an extended licence for a further period of 3 years. If, when you are subject to licence, you commit another offence or fail to comply with the terms of your release, you are liable to be recalled to custody and may serve the entire sentence in custody. The days which you have spent on remand in custody will automatically count towards the custodial term of your sentence.